A very good morning to you all. I'm Professor Colette Muller, the Dean of Research in the College of Law and Management Studies, and I'm delighted to welcome you to the 6th webinar session of the African Ombudsman Research Centre in 2021. I'd like to start by acknowledging the Chairperson of the African Ombudsman Research Centre Board, President of the African Ombudsman and Mediators Association, and Public Protector of South Africa, Advocate Busisiwe Mkhwebane. The Dean and Head of the University of KwaZulu-Natal School of Law and member of the African Ombudsman Research Centre's Board, Professor Manage Reddy. The Deputy Public Protector of Southern Africa, Advocate Koleka Kaleka. I also extend a warm welcome to our esteemed panel, comprising of the Ombudsman of Botswana and Regional Coordinator, Southern Africa, of the African Ombudsman and Mediators Association, the Honourable Augustine Makona Sotle, the Ombudsman of Victoria in Australia, Ms. Deborah Glass, a member of the National Council for Human Rights in Egypt, Dr. Ahmed Abu Wahfa, other excellencies and honourable ombudsmen who are able to join us, all distinguished participants and guests, as well as members of the media. Greetings, everyone. I welcome you on behalf of the Acting Deputy Vice-Chancellor and Head of the College of Law and Management Studies, Professor Brian MacArthur, who unfortunately could not join us today due to ill health. However, it's my absolute pleasure to welcome you to this African Ombudsman Research Centre webinar session themed Recalcitrant Respondents. This is a critical topic to deliberate upon as the Ombudsman Institute. Once a complaint is brought to the Office of the Ombudsman, the investigation process requires full cooperation from the respondents in order to give all parties concerned a fair chance to answer to the case at hand. However, we have all witnessed in our various African states the investigative process being hindered by the reluctance of respondents to participate in the proceedings. This often leaves the complainants frustrated and poses a huge challenge to the Office of the Ombudsman. As someone who works in a research space, I sympathize with the Office of the Ombudsman because without the cooperation of the respondents, the investigative task cannot be successfully concluded. As a research-led institution, I'm pleased that through the African Ombudsman Research Centre and through partnerships with organizations such as the African Ombudsman and Mediators Association and the International Ombudsman Institute, we are able to contribute to researching African problems. And through engagements such as this webinar, we are able to devise appropriate solutions. As I was preparing for today's webinar, I came across a research paper from the Best Practice Paper series of the International Ombudsman Institute, authored by one of our panel members, the Ombudsman of Victoria and Australia, Ms. Deborah Glass, in 2018. In this paper, titled Good Practice Guide to Dealing with Challenging Behaviour, Ms. Glass provides a valuable practical guide on how to deal with challenging behaviour. So, officers of ombudsmen that have not yet developed guidelines on how to manage problematic respondents will benefit from this paper, which can be found on the International Ombudsman Institute's website. In keeping with the mandate of the African Ombudsman Research Centre to promote capacity development, knowledge generation, and professionalism within African Ombudsman institutions, today delegates can look forward to hearing other esteemed panel members from the African continent share their insights on why respondents refuse to cooperate, how they have productively dealt with recalcitrant respondents, and the techniques that can be adopted by the African Ombudsman institutions to encourage recalcitrant witnesses to cooperate in investigations. Unfortunately, I'm not able to participate until the end of the webinar session, as I already had a full diary when I accepted to stand in for Professor MacArthur. However, I'm confident that the insights from the panel will empower the officers of Ombudsman in the furtherance of good governance, the rule of law, and human rights in Africa. I once again welcome you to the 6th webinar session of the African Ombudsman Research Centre in 2021. It is my pleasure to now hand over to Advocate Mkhwebane, the Chairperson of the African Ombudsman Research Centre, who will now formally welcome you. Thank you and have an engaging morning.
Thank you so much, Professor Amola, and for such warm welcome. And indeed, you would think that you are also part of the Ombudsman family. Your opening was so, and inspiring and very informative. So good morning, everyone. And acknowledging all the speakers who will be introduced by the facilitator, Advocate Galega, thanking the participation and the willingness to be here today by our regional coordinator, Ombudsman of Botswana, Mr. Makona Zotle. We appreciate the presence of Ingi from Egypt, representing the Ombudsman from Egypt, and we appreciate the presence of the Ombudsman from Australia, Ms. Glass, and we welcome Ignatius and all other esteemed Ombudsman who have joined us around the globe, and all the participants, and not forgetting the AORC team. You always outdone yourself, and indeed it's the 6th webinar which we are holding this year, and such a sterling work. One of the challenges that organizations worldwide have to confront over the last 2 years is which is remaining relevant and continuing to function even in the face of COVID-19 pandemic. So we are confronted with this pandemic, but we are continuing to work. So the Ombudsman and Mediators institutions across the globe have not been spared. So the pandemic has forced us to be innovative and reimagine our diverse roles in setting up where we had to continue working without being in physical contact. I was just discussing earlier with Ombudsman Glass that, these are the benefits actually of this pandemic, because now we are able to have speakers around the globe as AORC, and who will continue to inspire, share their knowledge with us. So since last year, the African Ombudsman Research Centre has been holding successful webinars and virtual training sessions in an effort to ensure that the capacity building program does not suffer merely because of the life and death need to keep apart. So I would also indicate that as AORC, we have our core mandate, which is conducting research, which is information sharing and capacity building and advocacy. So AORC is the engine of the African Ombudsman and Mediators Association, which has a mandate to contribute towards the African Agenda 2063, African Union Agenda 2063, the Africa we want. And we know that, as you will recall, Agenda 2063 is Africa's master plan for transforming the continent into a global powerhouse. It is the continent's strategic framework for inclusive and sustainable development. The plan is underpinned by 7 aspirations. And if we apply ourselves to our full potential as ombudsmen and mediators communities in the continent, we can make a real difference in respect of aspirations 3 and 4, which are about good governance, democracy, respect for human rights, justice, and the rule of law, as well as peace and stability. This webinar is also very critical for us as ombudsman institutions, and because we are also joined by one of our counterpart who belongs to the International Ombudsman Institute. And as well, we know that we have cooperation between AOMA and IOI. We have an MOU, which that MOU was signed in April 2013, which is assisting us to cooperate as well in various aspects like benchmarking through meetings, study visits, exchange of information. So we appreciate your presence here. And hence I said that the benefit of having COVID is that we have you as the Ombudsman from Australia who's participating in this. So the topic for today will assist us a lot because as Ombudsman institutions, we have persuasive powers, most of us around the globe, and we also have hard powers which are to compel those respondents to respond, especially the powers to subpoena the respondents, the powers of search and seizure in the process where they are not cooperating. But then we know that we most of the time adopt the approach of engaging them and as well showing them that by cooperating, we are assisting them actually to look good in the eyes of the various citizens of their countries. But then I think we will have to adopt various strategies which we will learn from our esteemed panelists. And I hope we will just be given an opportunity as well to ask questions and as well clarifications so that we can be able to learn more. Thank you so much to everyone. Welcome to this session, and I hope we will enjoy the session. Thank you. Over to you, Advocate Galega, as the facilitator of this webinar.
Thank you, PP. A very good morning to the President of AOMA, Chairperson of AORC, and the Public Protector of the Republic of South Africa, Advocate Mkhwebane, Professor Miller, Dean of Research at UKZN School of Law. Thank you very much. A very good morning to our esteemed panelists, Honorable Mr. Augustine Makgona-Sotle, Ombudsman of Botswana, EXCO member of AOMA Regional Coordinator, Southern Africa, Deborah Glass, Victorian Ombudsman, Australia, IOI board member, Dr. Ahmed Abdal Wahfa, member of the National Council of Human Rights of Egypt. Those will be our esteemed panelists for this morning, and a very good morning to all the colleagues who have joined in and to our audience today. This is a very critical topic, especially for the Ombuds family, as the President of AOMA has stated that we actually assist government in doing their work by collating the information that we do and the investigations that we do. Thus, it's very important that there is a cooperation between ourselves and as them, in most instances, as the respondents. Prof. Miller, we have taken note of the paper that you have referred to on good practice guidance dealing with challenging behavior of respondents. I think that is very critical for us as Ombuds, and that we have noted it, and we will respectively download that paper and share it with colleagues. Before I introduce our first speaker, I would like just to make the announcement that if we could all note, those who are on the platform, that due to time, there will be no live question and answers. Therefore, participants are encouraged to please submit their relevant questions to Frankie or Marion, or even through the chat box, question and answer box here on the platform. And then thereafter, we will then read them out and they will be responded to by the esteemed panelists. Let me also not forget to greet our very active team from AORC, which has made this webinar possible. Please allow me to then introduce our first panelist, who is no other than Mr. Augustine Ntomane Makgonasotle, who is the 4th Ombudsman of the Republic of Botswana. He is a distinguished legal practitioner and public servant who has extensive experience in the field of human rights. He was appointed into office in 2016, and Mr. Makgonasotle currently holds the post of Regional Coordinator for African Ombudsman and Mediators, as I've already stated, and he's been elected to the post at General Assembly in Rwanda in 2018. From 2017 until 2016, he has served as the Secretary for Defense, Justice and Security in the Ministry of Defense, Justice and Security, where he's been responsible for ensuring that Botswana complies with her treaty obligations, especially the reporting of domestication of human rights conventions, treaties, and protocols under various human rights treaty bodies. As Secretary for Defense, Justice, and Security, Mr. Makgonasotle has been further responsible for policy formulation and development of legislation. Without a doubt, he is indeed an esteemed and highly respectable legal mind, and we are honored to have him today as our first speaker. Over to you, Mr. Makgonasotle.
Unmute yourself, sir. We can't hear you.
Honorable Makgonasotle. He was on the platform. He still is. Maybe he's having some connectivity problems.
Can they hear you, sir? Can you hear me?
Yes, we can hear you now, sir. Thank you.
Thank you very much for that hiccup. I was just saying thank you very much, Madam Facilitator, for the introductory remarks. And let me take this opportunity to greet my fellow ombudsmen and their staff who have connected to this discussion. I should also want to thank AOMA for giving me the opportunity to share my humble thoughts on this very important topic of the recalcitrant respondents. I think, Madam Facilitator, this topic is very, very opportune for us to discuss, especially in these times of the coronavirus, the COVID-19 pandemic, because you can imagine that most of us are stressed, we are traumatized, but we have to keep on with our operations. And of course, even those people who come before us to make complaints, they come with their own stresses as well due to this situation. I'm going to discuss the subtopic of why respondents do not, or respondents refuse to cooperate. This issue is very, very important because for us to do our work, to be effective and efficient, we need respondents to cooperate with us. We need them because we rely on the information that they may be having at their disposal, the evidence, documentary or otherwise, that may assist us in the investigations that we conduct. But also I want to say that by respondents here, I'm sure that I won't be wrong to assume that we are referring to both public officials and members of the public who may be required to assist the ombudsman in his or her investigations. Public officials, because they are the people that will be complained of or complained about. And the members of the public invariably will be the complainants themselves who come in before us to lodge those complaints. At other times, you can call these people as difficult customers because they give us challenges in terms of when they're interacting with us to give us information that we require. First of all, I'll start with the public officials or the government departments that we deal with. In my view, there are a number of reasons why there's a lack of cooperation from public officials or government departments that are complained of. The first issue that comes to mind is the lack of understanding of the mandate of the Ombudsman by the public officials themselves. They may not understand the mandate. They may not even have familiarized themselves with the legislation that is setting up the office of the Ombudsman. And that may make it very difficult for them to appreciate the importance of their cooperation. Now, you find that most of these public officials who have to respond to our inquiries, they may believe that they are doing us a favor by availing information. They seem to think that because the Ombudsman is not a court of law, they are not bound to cooperate. And that, in my view, stems from the fact that they are not really appreciative or understanding of the mandate that is statutorily given for the office of the Ombudsman. The second issue that I want to raise is that they may also consider the Ombudsman to be a busybody who wants to control their actions. Hence, they will be less inclined to cooperate. This is evidenced by the fact that they would at times just ignore the correspondence without advancing any reasons. Can I ignore the correspondence from the Ombudsman, making inquiries without advancing any reasons? So you find that in as much as we get complaints from members of the public about the non-response by the government departments themselves may not even respond to us. And this thing happens on a daily basis. So this is an issue that also makes us difficult for us to do our operations in a very effective and efficient way. The other issue that I would want to raise is the issue of the complainants who might come before the Ombudsman already stressed, already angry and agitated, because in their dealings with the department, they have been frustrated. They could have been sent from pillar to post. At times, they find that the doors are closed. The officials, including even the leadership in the ministries, are not accessible to them. So they end up really having that pent-up anger. And when they come to the Ombudsman, they're very, very impatient. They want to be assisted as of yesterday. Sometimes that creates a problem for us because you need to sit down, calm them. You have to calm them and make sure that before they speak to you, they have now they're calm and they're less stressed. The other issue that I want to raise, which also makes it difficult for these organizations or public officials to cooperate, is the poor and improper records keeping and information handling within the department. We are very much aware that the records management strategies, they help to keep organizations efficient and productive. The records help organizations to keep track and provide evidence of any administrative or executive transactions that might have taken place between the department and the members of the public. So you may find that public officers may refuse to respond because of lack of information, resulting from poor and improper records keeping and information handling within the department itself. The fifth issue regards to malice, what I regard as malice or bad faith on the part of the public officials. Some officers just refuse to cooperate because they believe that they can simply ignore the Ombudsman. This type of officers are the ones who sometimes will be breaking and saying that the Ombudsman is a toothless bulldog who cannot do anything to them, even if they withhold information needed in the investigation. In as much as we do have all those other strategies that we can use to get information, such as subpoenas and others, they still have those that have that entrenched belief that after all, the Ombudsman is not a court of law. There's nothing they can do to us. We can just ignore his inquiries. The sixth issue relates to the general unhappiness and poor morale on the part of public officers. I mean, I think this happens everywhere. It's not only in my country. I think in many countries, some public officers are disgruntled and demoralized, demotivated due to poor conditions of service. As a result of that state of affairs, they tend to address their own issues. They tend to be more concerned about their own issues and forget that, or rather don't even attend to complainants when complaints come before them because they are busy, they are worried about their own welfare and everything like that. And they may even not even care to respond to the Ombudsman's inquiries because that time is taken up by their own personal issues. There's also the concept, what I call the concept of floodgates. In this instance, we find that public officials, even if they may appreciate maladministration and injustice caused by it, they may be hesitant to respond or take corrective action on the case at hand because of fear of opening what are called floodgates due to the high numbers of similarly affected individuals. The thinking here is that if I take this matter and I'm aware that there are so many others or if I respond on this issue, there are many others in the department or outside the department who are suffering similarly to this complainant. More cases are going to come to the Ombudsman and I'm going to be put on the spot. There's a lack of transparency also amongst our public officials. They operate under what I call a code of secrecy. Here, what happens is that even though the legislation establishing our offices is quite clear that there's no room for secrecy or confidentiality pertaining to Ombudsman's inquiries, they still have a deep, they still have a deep sense of that they can just hide information from the Ombudsman and not open up to the Ombudsman when required to do so. So everything is hidden. They don't give information. They'll rather you as Ombudsman fish for it or even go the route of ultimately of issuing out subpoenas and so on and so forth. The last thing that I wanted to touch on was, okay, now the ninth one is the behavior amongst the officers. Some show utter laziness, which we are observing in the public service. They are lazy. They'll just, each time you follow up a matter, they'll just say, well, we forgot to look into it, as if that should be an excuse. And this kind of behavior goes unpunished, hence it keeps on carrying now and then. There's also the last part that I wanted to touch on is the perception that they have that, of course, the Ombudsman only issues out recommendations, which are not binding, in terms of, especially in this country. In our legislation, we only issue out recommendations. Our decisions are not binding, unlike in other jurisdictions, like in South Africa and so on. So they tend to just ignore. They say, after all, even if they give the recommendation, they're not going to cooperate, they're not going to implement it. Otherwise, after all, the Ombudsman, his decision is not binding, and he also does not have enforcement powers. So these are the issues that sometimes you can see that these are the underlying causes or reasons behind the lack of cooperation from the public officials. If I may touch on the complainants themselves who come to us to lodge complaints, sometimes they are very difficult to handle for various reasons. Because of their character. You might find that these are very dishonest people who have the tendency not to tell the truth, or they will hide information from you, even the information that is within their possession, which can assist you to quickly resolve the matter. They will rather tend to give you what they think is favorable to them and not give you the whole picture. So sometimes this gives us a lot of problems because then we have to go out and chase for information and get even from. Some are abusive, they can be insulting. These are character traits that you find that the person is just like that. There's nothing that we can do about it. During the course of the investigation, okay, even at the end of the investigation, they may not even accept the outcome of the investigations and come up with all spurious reasons and defenses, and still claim that the complaint has not been properly investigated, even though it has no merit. As you go along investigating the matter, they may just even keep quiet, go silent, without even informing the ombudsman that they have lost interest in the matter which they have brought before you. They may also be unwilling or to accept final decisions. They may try to reframe their own complaints in an effort to make it to have it taken up again, even if it was concluded. But the problem being that it was concluded not in their favor, they'll still come back. They persistently demand reviews of their complaints without presenting any new information whatsoever. So these are difficult characters that we always come across in our daily operations. And I think some even have a serious mistrust of the Office of the Ombudsman and a very deep-seated belief that the Ombudsman is part of the executive or is part of the government. So they are unable to appreciate that the Ombudsman is a neutral mediator. He is neither the defender of the administration nor the advocate for the complainant. These are people who have this character traits and who are also. Now, in conclusion, I want to say, Madam Facilitator, that a solution, as far as I'm concerned, to these above problems is just one. It's mindset change. How do we do that? How do we change the mindset of public officers and also our complainants out there who come to us to lodge complaints? For me, I think a concerted effort by the office to inculcate in our public officers the principles of good governance is very, very key. And this can be achieved by teaching public officers best administrative practices. As for the public, members of the public, I think a robust outreach program to educate the members of the public on the mandate of the Ombudsman and the importance of the office insofar as democracy, good governance, and the rule of law is concerned is very, very key, very, very important. Also in terms of its role in promoting and protecting human rights. I'll stop there, Madam Chair. I hope I have not taken too much of your time. Thank you very much for the opportunity.
Thank you very much, Honorable Makhonasotle, for such an insightful presentation. I mean, if we could all note indeed the aspects that you've spoken on, it's really what we go through, and it is very critical that you have outlined each and every aspect so that also when we deal with these investigations, we are able to pick up what could be the cause of the non-response or cooperation, specifically or more particularly from the respondents, which really also puts us on the back foot with the complainants as they see us as being the ones who are not responsive to their needs, as frustrated as they would be at that particular time. I think of most focus is really what you ended with, Honorable Makhonasotle, on the solution. How do we change the mind? We need to change the mind, and how do we do that? As part of our outreaches, ensuring that we inculcate a culture of good governance, the rule of law, but also the respect for the office of the Ombudsman, and that it is an office that is envisaged in our constitutions, and cooperation from the state is mandatory through the constitution. Thank you very much for that insight. We will now move over to our second speaker. Ms. Deborah Glass is the Victorian Ombudsman. She was appointed to a 10-year term in March 2014. Her office looks at the decisions and actions of Victorian government departments, local councils, statutory bodies, and their contractors. Ms. Deborah was raised in Melbourne and studied law at Monash University. She practiced law briefly before leaving Australia, working for an investment bank in Switzerland before moving into a career in financial services regulation in Hong Kong and London. She then moved into police oversight and became a commissioner of the Independent Police Complaints Commission of England and Wales, heading up criminal and misconduct investigations into the police. In 2008, Ms. Deborah Glass was appointed IPCC Deputy Chair, and in 2012 was awarded an OBE for her service. Ms. Deborah Glass is on the board of International Ombudsman Institutes, which connects more than 190 ombudsman offices worldwide, and is also a member of the Australian and New Zealand Ombudsman Association. Ms. Deborah Glass is committed to ensuring fair and reasonable decision-making and to improving public administration. She holds a firm belief in public sector integrity and advancing human rights. Without a doubt, she's really a panelist who is also going to give us insight into the topic that we are dealing with today in dealing with recalcitrant respondents. Welcome to you, Ms. Deborah Glass, and over to you, ma'am.
Thank you so much, and good morning, good afternoon, good evening, wherever you are joining today. I'm delighted to be greeting you from Australia to participate in your seminar. I know that African ombudsmen have a strong and proud history. And much as I'm fed up with online meetings, it was the only way I could communicate with my own office for about 15 months. I must agree they are a wonderful opportunity to interact with colleagues from afar. And I must also say that recalcitrant respondents is a terrific topic, and it is such an important issue for ombudsman officers around the world. So I'm very happy to provide an Australian perspective to that. So in my presentation today, I want to give a brief outline of my office and its powers. And I want to give some practical examples of how we deal with the subject matter of this seminar. And just as a brief aside, you kindly referenced the paper I wrote about dealing with challenging behaviour. And my predecessor, the previous speaker, the Honourable Ombudsman from Botswana, talked about challenging behaviour of complainants as well as the challenging behaviour of respondents. And I should explain that paper focuses on difficult complainants, which is something that all ombudsmen around the world experience on a daily basis, may I say. But what I do want to focus on today is the other side of the coin when we deal with the difficult respondent. But let me start with some context. I'm sure I don't need to tell this audience how old the institution of the Ombudsman is, but I'm so proud of our history that I like to repeat it. Because the concept of the Ombudsman goes back at least to ancient Rome, you know, the tribunes of the plebs, if not earlier. Although, as we know, the first Ombudsman by that name originated in Sweden in 1809. And since then, ombudsman offices have multiplied around the world, especially from the second half of the 20th century. So the International Ombudsman Institute, of which I am very proud to be a director, has 226 members now in 123 countries. And it's the main subject of each board meeting to consider new applications. So it is wonderful to see the growth of this incredibly important institution around the globe. Now, I understand that Tanzania created the first ombudsman institution in the African region back in 1966. So I want to congratulate Africa for beating Australia, not to mention most of the rest of the world, in being such an early adopter of the Ombudsman institution. Now, the first Australian ombudsman appeared in 1971, and my office, the Victorian Ombudsman, in 1973. So we've been keeping governments on their toes for nearly 50 years now. Now, here are some quotes that I thought I would share with you from the parliamentary debate for the creation of the Ombudsman back in 1973. One of them I think is rather prescient, the other perhaps less so, but I particularly like the one about the power of reporting to Parliament and the impact that has on the actions of public servants. So while around the world our names may be different, we may or may not actually be called ombudsman and our jurisdictions will vary, we have some core things in common. We exist because of the imbalance of power between the individual and the state. The Ombudsman is an independent authority providing the ordinary citizen with a safeguard against the abuses of state power, whether that's deliberate, negligent, or simply uncaring. So if we're going to be effective in redressing that imbalance of power, we need some powers ourselves, or governments and public servants simply won't bother to take any notice of us. Now, I can't give you a full comparative study of ombudsman powers around the world. Perhaps the African Ombudsman Research Centre has done that work already, but I understand that Australian ombudsmen are regarded as having a pretty good set of powers. We all operate as being the equivalent of a standing royal commission. And for those not familiar with Royal Commission powers, that means that we have the power to summons witnesses and documents, and we have the power to require people to answer questions. Now, unlike Royal Commissions and some of our anti-corruption bodies, we carry out our work in private, though we also have the power to table reports in Parliament, which in my view is the most impactful power we hold. We table our reports directly to Parliament, not through a minister, whenever we choose, and of course our reports are then immediately available to the media. So, turning to the question of this seminar, how do we deal with recalcitrant respondents? The key point is that we can issue a summons requiring them to attend the interview. And that means there are real consequences if someone is very recalcitrant and fails to attend. It is an offence punishable by a prison sentence. So let me tell you how it actually works in practice. First, let me reassure you that Australia's prisons are not full of people who failed to comply with an ombudsman summons. I've been in my role for over 7 years, and I've never yet needed to enforce a summons, and I'm not aware of it having been done in the 40 years before that. So first, of course, we seek people's cooperation. Usually we'll tell them at an appropriate time that we're investigating, what we're investigating, and we invite them in for an interview. They usually say yes because they know we have the power to summons them. Sometimes people ask to be summoned. For example, in certain situations, people don't want to be seen to be cooperating with an ombudsman investigation. It's better for them to be able to say to their boss, I had to talk to them. They issued a summons. And while people are required to answer questions, they also have some rights, including the right to legal advice and representation. What I would like to do, though, is explain. So we issued 55 summonses last year, and that's about once a week. So as you can see, it's not uncommon that many of those would have been to banks who require a summons to produce financial records. But some of those summonses were to deal with the question of recalcitrant witnesses. So to illustrate this point, I'd like to give you an example of what was probably my most politically sensitive investigation to date. Now, this case started with newspaper headlines about a political scandal, which alleged that the government of the day, which happened to be the Labour Party, only got into power because it was paying its political campaigners out of the public purse by claiming they were electoral officers. Now, these campaigners were mostly a very enthusiastic group of young people called the red shirts because that was the colour they wore to campaign. And I should also explain that the word rort, which I actually didn't hear in the 30 years I was out of Australia, is a common Australian word for scam or fraud. Now, the case came to me as a referral from the upper house of Parliament, which triggered a furious debate about the Ombudsman's jurisdiction to investigate members of Parliament. Normally, elected officials are not in the Ombudsman's jurisdiction, but there's a special provision in my Act that allows Parliament to refer any matter to the Ombudsman, and the Ombudsman must investigate. So, here is a legal question for you. Does any matter override the Ombudsman's jurisdictional limits? The upper house of Parliament, which the government didn't control, thought that it did, and the government thought it didn't. Now, I didn't really care one way or another, but I didn't like the idea of either side of politics telling me what I could or couldn't do. The important thing for me here was not my jurisdiction, but my independence. I was also very mindful of recalcitrant witnesses. The government did not want me to investigate and was arguing I had no jurisdiction. And that would mean that no witness would cooperate voluntarily, and as soon as I issued a summons, it would be resisted and the whole matter would end up in court. So I decided to take the question of my jurisdiction to court myself. I applied to the Supreme Court for a determination, and I invited the Parliament and the government to join the proceedings if they wished, making it clear that I would remain neutral. As I said, it didn't matter to me whether or not I could investigate MPs, but I wanted the court to tell me. Now, the Supreme Court of Victoria said I could, and the government appealed this all the way to the High Court of Australia and lost. I waited for the outcome of the first appeal before starting the investigation, and then I decided to get on with it. Now, the investigation involved 23 members of Parliament and their electoral officers, nearly 50 people, and most of them were extremely, or would be, extremely reluctant witnesses. So the approach we took was to take a sample set and invite them for interview. We invited 8 electoral officers, followed by 3 members of Parliament. In the end, every single one came to an interview voluntarily, although in almost all cases, agreeing at the very last minute, just before we issued a summons. Now, of course, we couldn't ignore our other recalcitrant respondents, and our approach then was to invite them to comment on a draft. Because for the witnesses we did interview, we were able to combine a very detailed account of the way the campaign and the payments worked. So we called this a request for information, and we sent it to all of the other members of Parliament and invited them to tell us if we were wrong. This was completely voluntary. They didn't have to respond. And we said, if you want to give us your account and interview, that's fine. We'll be happy to interview you. But if we don't hear from you, we will assume that the version of events we're sending you is correct. Now, finally then, we prepared a draft report, which was critical of a number of the MPs, and we sent it to each of them as part of the adverse comments process. Now, I am sure that you are all familiar with the principles of procedural fairness. This process, though, is not only necessary as a matter of fairness, it can be an extremely useful way of dealing with recalcitrant respondents, especially if you don't have the powers to compel. What matters here is to have the power of publication. So overall, we managed to complete a very thorough investigation despite the obstacles, and I think enhanced the reputation of my office for independence and, I think, for courage. Now let me end with just a few thoughts. I sent this to my staff on my first day in the role over 7 years ago, that our most impactful powers are the ones we don't need to use because everybody knows we have them. And ultimately, while we cannot compel, we are most effective when we persuade. So like most Ombudsman officers, I too cannot enforce my recommendations, but my reports must be pretty persuasive because about 95% of them are accepted. And that is where we really make a difference. Thank you very much.
Thank you very, very much, Honorable Class. That was very insightful. I mean, how to productively deal with recalcitrant or difficult respondents. I think what is critical and highlight was the case you had to take up, the red shirts case where the Ombudsman's jurisdiction was being challenged, and it often happens even in our country in South Africa, where the respondents do not want to be investigated by the public protector. The issue of jurisdiction quickly pops up. But what is important in what you are saying, even in your write-up, is that the real fight here was not just about the jurisdiction, but it was about the independence of the Ombudsman. Now, indeed, how do we then use our powers to ensure there is cooperation for Ombudsman's independence to be able to be recognized? The hard powers of summoning them is always the last option. Hence, it's always best to try and get cooperation through other means, such as in the form of requesting information and so forth. But in most instances, ombudsmen are more or less forced to then issue summons and subpoenas accordingly. Thank you very, very much for that insightful presentation. I think really it is for us as ombudsmen to really take note and ensure that we bring that into our respective jurisdictions. And I think when you started off, you touched on the paper that you had penned down on dealing with challenging behaviors, mostly focusing on difficult complainants. I think that really should be a topic, President of AOMA, Chairperson of AORC, and colleagues at AORC, that we indeed should look at and focus on for the future. It is difficult to speak about the respondents without speaking about the difficult complainants. Thank you very much, Honorable Class. We will then move over to our last speaker for the day, Dr. Ahmed Abdal Wahfa, who is a member of the National Council of Human Rights, Egypt, and professor of international law at the Faculty of Law, Cairo University. He has written a number of publications in the field of human rights, in addition to articles in scientific journals and periodicals in Arabic, French, and English. Since 2018, he has been in charge of Universal Periodic Review with the Organization of French-Speaking African Human Rights Institutions under the Francophonie, and has made many contributions to it. Generations of students and researchers at the CNDH recognize him for his rich scientific background and remarkable kindness. That is so wonderful. Normally, lawyers are not people who are mostly favorable with being kind. So that is quite a great attribute. Today, Dr. Wahfa is going to focus on techniques to encourage recalcitrant witnesses to cooperate in our investigations. That is quite an important tool that we should take note of. Over to you, Dr. Wahfa. Kindly unmute yourself, Doctor.
Good morning.
Morning. Good morning.
Do you hear me?
Yes, we hear you perfectly. Over to you, Doctor.
Thank you. Thank you, Madam Facilitator. And good morning to you all. those who participate in this meeting and those who have organized it, as well as those who are hearing and seeing us now. I begin by saying that the institution of Ombudsman is a very important one for the protection of human rights and fundamental freedoms. However, this institution faces some challenges, amongst them the question of recalcitrant respondents in investigation. And as you all know, this may have some drawbacks with regard to our job to protect human rights and fundamental freedoms. Amongst these drawbacks are the following. This prevents the collection of facts related to complaints. It hampers as well and have a negative effect on the process of investigation. And finally, it may lead to the non-punishment of responsible for the breach. In fact, negative cooperation on the part of respondents makes the perpetrators remain unpunished. With regard to the National Council of Human Rights in Egypt, and concerning this question of ombudsman, I would like to highlight two remarks. Number one, our NCHR is open to any cooperation and exchange of information related to that topic with any other sister states in Africa. It also supports any activities made by African Ombudsman witness the role played by the president of NCHR of Egypt, Mr. Mohammed Faye, in his capacity as the president of Arab Ombudsman Institution, as well as his experience on the African level. He has also many contacts with other ombudsman units in the continent. That being so, with regard to our problem related to recalcitrant respondents, you all know that this attitude from respondents may be due to many reasons. One of them is suspicion and doubts. Secondly, insufficient knowledge of NCHR role and capabilities. And finally, confusion of the role of council with that of other entities, such as those of civil society organizations and units, and an ancient human rights units of state administrative bodies. Those are the main reasons in this regard. However, in order to improve its role in this regard, the Council has resorted to many techniques, the most important of which are 6. Number one, protecting the confidentiality of names of whistleblowers and respondents and witnesses in any case before the court. Number two, offering legal assistance through researchers working in specialized units, mostly lawyers and researchers with a wide-ranging legal and Sharia law background. Number three, heads of branches of NCHR in the various governorates in Egypt plays more effectively than in capital their role in to communicate directly, communicate with citizens in their respective governorates in order to arrive at an amicable solution of the problems raised. Number four, in the same vein, the NCHR is endeavoring to promote its e-complaint system, bolster the capabilities of the specialized researchers by participating in all relevant workshops similar to that, to the current one, and obtain all the training manuals on the ombudsman and intermediaries. Number five, NCHR is seeking to train staff on interviewing techniques to encourage those who are apprehensive or recalcitrant to answer questions, to positively participate in boosting and promoting the respect and the respect of the system of basic rights and fundamental freedoms of citizens. Those are some techniques made by the Council. Added to them, the question of the lack of funds. In fact, in this regard, the Council seeks to boost its financial resources in order to reach the public, since its limited financial resources now hindered it from undertaking necessary activities and its complaints team from playing an optimal role in this regard if compared with other activities by the Council before. And this is in the report sent to you by us, mentioned in various occasions and with regard to various problems such as those related to Syrian unrest in several governorates and the Maspero incidents and the Rabah the square set dispersal, etc. This is written in what we have sent to you in this regard. So by that, I come to the end of my intervention. I know that I was so too brief, but I think that this is an outline of what is made by the NCHR in Egypt with regard to the question, the very important question of recalcitrant or reluctant respondents. So in the final analysis, I thank you for your patience and for your attention, and for any other meeting, goodbye for you all.
Thank you very much, Dr. Wahfa. That was brief but precise. It took us directly to the issues that we need to focus on when dealing with these recalcitrant respondents. I think of importance really is issue of protecting the confidentiality of the witnesses, offering legal assistance, communication, education, how research plays a part in this, and training and interviewing plays a part as part of the techniques for us to deal with the challenges that we experience with the recalcitrant witnesses. Thank you very much. We have now reached a stage where we go to the Q&A session. I will go through the chat box. If I miss anything, Frankie, would you kindly assist me? I'll go to the first question that is there. I'll start with the questions raised before the webinar started. Question number 1, may the panelists kindly note the questions. May I raise a question as to the role of impact of fear of victimization and intimidation in the genesis of recalcitrant respondents? This is by Professor Hussein Vauda. The next question is, what is the place of African values and tradition in African ombudsmen? Mohammed Abedin. How do you identify and handle difficult respondents? Annie Kalebwe. My panelists, please note the questions in line with their topics. And then the last question is, what are the strategic options that can be developed for this situation? Just to allow for chronology, may I then request the panelists to please respond to these 4 questions, and then I'll move on to the other questions. We will start with the first question. Was it noted? The role and impact of fear of victimization and intimidation. I think, Honorable Glass, that would be a relevant question for you.
Well, I'm not quite sure whether is it a fear of intimidation of the Ombudsman's Office or something else. What I would say in response to that, I think intimidation is not something that we do, but what I think indeed any Ombudsman Office does. But what is, I think, would be true is that there is a certain amount of fear of the Ombudsman's Office. I prefer to think of it as respect rather than fear. There is no reason to fear us, but the Ombudsman is a powerful institution, and I think we need to use that power carefully and wisely. And if that power results in people respecting the office and being a bit afraid of it, that's not such a bad thing, as long as we are using our power in an appropriate fashion and we're not abusing it. But I think that also works to our advantage, because in the sense that even if we don't use the powers we have, that people will want to be seen to cooperate. And I think my colleague, the Honourable Ombudsman from Botswana, made this point in his presentation, that that people want to be seen to be doing the right thing. And I think that is that can be a very powerful indirect way of achieving the same objective.
Thank you, Honourable Class. The next one. I think Honourable Mahana Sotle, what is the place of African values and tradition in African Ombudsman?
Thank you, Madam Facilitator. I'm not too sure if I really understand or am competent enough to answer that one. But my thought would be that this institution or this concept of ombudsman, I don't think it's alien to our situation, to the African situation, because I believe that from time immemorial, there's been some kind of a scheme or institution that sort of played that role of an ombudsman in our societies, where there would be someone or someone who would be, as they always say, will be there as the in-between, the go-between the authorities and the people. Somebody who could listen to the complaints of the people and be able to bring them to the authorities, whether it's a king or whatever, or our chiefs and so on, and be able to make sure that the authorities hear about these complaints and do something about them. And therefore, I would also assume that our cultural practices, our values and everything were embedded in the whole thing. The culture of Ubuntu, that you are a person because of other people, of other persons. You are part of a community, and therefore whatever problems you have will have to be shared by the whole community to assist you to resolve such issues. I think those cultural practices and those beliefs and efforts, I believe personally that they are embedded within that institution of ombudsmanship, especially about to respect for a fellow man, the ability to empathize and listen and be able to assist when somebody has a problem. I think this is all what the ombudsman does on a daily basis, listening and assisting and making sure that issues are resolved in a very amicable and very accommodating manner. So I think really those things, as far as I'm concerned, are part of the whole scheme. Thank you very much.
Thank you, Honorable Mahonaswate. The last questions really, Dr. Wahfa can just summarize on them, but I think they have been touched on by the respective panelists, and it was actually the areas of focus on how to identify and handle difficult respondents and what are the strategic options that can be developed for this situation. Dr. Wahfa?
I think we've lost him. We can move on. I don't see him on there. Yeah.
Okay, that's fine. But in any event, I think those questions have been answered already.
So I can, I hear you now.
Oh, you hear us. Thank you, Dr. Wahfa.
Could you repeat? Could you repeat what you have said?
How do you identify and handle difficult respondents? What are the strategic options that can be developed for this situation?
I think this may be summarized in 3 points. Encouraging people to cooperate and tell what they say, they see and know. Number 2, protecting those who tell the truth from being followed. And number 3, I think, preventing competent authorities from following or punishing those who cooperate and those witnesses who are willing to tell what they say. Those are 3 pillars in identifying any strategy for the question of respondents to or recalcitrant or reluctant respondents with regard to the question of protecting human rights and fundamental freedoms.
Thank you. The next question, my question borders on how to tackle or address the issue of the Ombudsman being a toothless dog. May I please hand that to our Honorable President, Advocate Mkhwebane.
Thank you, facilitator, and thank you so much for all the inputs, but I'm placed on the spot here because we do have experts who've presented. But then what I would say is that that question, the main purpose of an ombudsman, our processes are inquisitorial. We are not accusatorial in nature. We are not a court of law. When the Ombudsman institution was created, it was to make sure that we have that upper voice and we assist the voiceless to have a voice, and also to reflect and show those who are in power, who have deep pockets, that this is the correct way to deal with issues. We are not supposed to be fighting with those who are in power, but we should be having persuasive powers over them so that they can see what they need to do. Well, in South Africa, we have the EFF versus the Speaker Constitutional Court judgment, which was dealing with the Nkandla residents of the former public president. So that judgment made the public protector to have remedial actions which are binding unless set aside by a court of law. That made our remedial actions as if they are court orders. And that led to a very serious challenge for the institution, because since then, we have exorbitant legal fees, because no one would want to be held to account, especially people, those government officials, ministers, presidents. They feel that possibly they've got an upper hand. And remember, they are the ones who are funding these institutions. They are the ones who must make sure that these institutions are independent. But then if you'd want to have those powers, I think persuasion. As the Ombudsman of Australia has indicated, that they use their hard powers as a last resort. So I would urge all institutions to be able to deal with the challenges of these recalcitrant respondents in a way of always engage them, escalate to, if it's about the members of the executive who are not cooperating, try to work with the members of the legislature, the speakers, or as well, if it's about the head of a department, try to work with the minister, the MEC in those countries, so that we avoid to want to have binding powers as this institution, because we are not a court of law. And as well, yes, we need to operate within the law, and we need to act without fear, favor, or prejudice in that aspect. But then I would say, let's make sure that we engage the government institutions and the officials, and let them continuously understand what is our role. Yes, no one would want to be embarrassed. And unfortunately, as ombudsmen, we go to the very serious powers or raw state powers of the state, and they have the resources which we do not have. But then I would say, let's continue persuading, and hold meetings. Now, again, it's very easy for us. People can't come back and say, I've got meetings, therefore I can't meet with you. I mean, virtual meetings are there, even if it's overnight or very late at night. That can be done so that they can understand what needs to happen. Yes, unfortunately, sometimes we use our hard powers so that we can make sure that we secure the presence of that state institution. Thank you, Facilitator.
Thank you so much, Honorable Mkhwebane, and I think that was very well tackled. I know this, you're very passionate, you're actually an expert on this subject, hence I asked you. Honorable Class, this question I'll give to you because of your paper on dealing with complicated complainants. The question is, how does one deal with a situation where the complainant decides to no longer provide additional information or withdraws the complaint when, as an investigator, you have already identified breaches on the part of the government institution? Do you abandon the investigation despite the noted breaches?
Not necessarily, no. It really comes down to how serious is the situation. Like many ombudsmen, I have the power to investigate on my own motion, so I don't need a complaint to investigate in the first place. If it was something relatively minor and the complainant ceased to cooperate, well, it comes down to what is in the public interest. If these are very serious breaches and it is in the public interest to continue an investigation and expose them, then that's what I would do.
Thank you. Here's another one for you, Honorable Class. There's a comment that they do not hear much about the Ombudsman Office in Australia. Would it be possible to educate the public in Australia about the Ombudsman's Office?
Well, it's something I do on a daily basis. It's every Ombudsman Office I have never heard of a single Ombudsman Office that says they have too much money and too many staff, to go out and educate the public. So it is always something that we want to do, and we never have enough resource to really do as much as we would like. But absolutely, I see it as one of the absolute core functions of my own, personal role, to go out and educate the public, and I do a lot of it. Of course, the days before COVID, I would give a lot of speeches, but now I do it on Zoom. But even now, I for example, I do radio programs. I will engage with radio presenters who cover great parts of my state, and I take questions from the public, which can be very entertaining sometimes, and very frustrating at other times. So all of this is part of educating the public. But it is I think we have to be realistic about this. In Victoria, for example, I have about 100 people in my office, and there are over 6 million people in Victoria. So what ability do I really have? And they're very diverse. Some people live on farms, they live in the cities, they speak different languages. So, what ability do I have realistically to get through to everyone there? But it remains an objective, and yes, I will regard at the end of my term some of the success is how far did I achieve that objective.
Thank you. The next question, Honorable Mahona Swatle, to you. Could the popularity of the Ombudsman Office with the general public encourage recalcitrants to participate?
Thank you, Madam Facilitator. I think so, because as I said in my presentation, we have the duty to educate everybody about our office, our mandate, what we do, and what contribution we make towards good governance and the rule of law. So I think if these public officials, especially, are trained or are sensitized about the importance of this office, they will see the need to participate, to cooperate with the Office of the Ombudsman. As I think, as the Madam President said earlier, you see, it's all about persuasion. It's all about really making people understand that we are not here in vain. We are here because we are created by law, by constitutions, by acts of parliament, and we have a serious role to play in terms of promoting constitutional democracy in our countries. So I think it's incumbent upon them to really cooperate to really enhance democracy and good governance and the rule of law. Thank you very much.
Thank you, Honorable Mahona Swatle. The next question on dealing with stressed complainants and public officials that do not cooperate with ombudsmen, what mechanism through experience may be efficient? This question has been answered extensively. Honorable Wahfa, I'd ask you to please deal with the next question. Some of the respondents are uncooperative because of the expenses that would be incurred during litigation. How could we address the issue? Dr. Wahfa? I see that there's a hand by Bunmi Ajayi. Ajayi, we had made an announcement when we started off that we will not be taking questions verbally, that questions should be on the platform. They should be written in the chat box. Thank you. Over to you, Dr. Wahfa.
Yes, I think to face such a problem, the problem of expenses, which may lead those witnesses to be reluctant ones, may be faced by ensuring a certain financial assistance, either by the National Council of Human Rights themselves, or even by the government itself, in order to give a legal assistance to those, or a legal or a financial assistance to those implicated in cooperation with investigators. Thank you.
Thank you. Honorable President, Advocate Mkhwebane, this one is for you. Has any of the panel or other participants here tried using mediation to resolve any of the complaints brought to them?
Thank you, facilitator. Yes, as Ombudsman, we have additional powers, well, like the Public Protector and most others. They have that role of mediation and conciliation, which is called alternative dispute resolution. And that is what we utilize most of the time, because you'd find that 95% of the complaints which we receive, especially the bread and butter issues, we utilize that, or service delivery related complaints. We utilize the mediation process or the conciliation process. And those should be finalized expeditiously, because once you bring the parties together, you discuss, you find common grounds, you resolve the matter, then it's very quick to finalize those. Unlike an investigation, which will take a long and a protracted period, you would find that as Ombudsman, we are also being accused, or we will be accused of delaying to finalize the matter, and also then not leading by example, because we are investigating undue delay, that maladministration. So sometimes we'll end up being accused as well of delaying to bring solution to the matter. So indeed, a lot of the times we do that. Hence I said, if you are persuading, writing letters, write letters, call for a meeting, then where all else has failed, then you can use the last option of your hard powers, which is to subpoena and to the search and seizure powers, because we do have that. Unfortunately, in South Africa, we've never utilized that. We're still researching and finding a way of how we can use that if it comes to that level. But then mediation is key. And remember, we are saying some of our counterparts are called mediators, especially in the Francophone countries. And the mediators, we see our role contributing to peace and stability in Africa, because we are calling as well heads of states to involve us when our countries are sending envoys in other countries. If you use your local mediator or ombudsman, when those international envoys are leaving, at least you have an independent mediator who can continuously bring the parties together so that there is that sustainability of the solution. So we see ourselves contributing to that aspiration. Thank you, facilitator.
Thank you, Madam President. One last question that I'm going to read out. Honorable Glass, would you kindly deal with this? What is the strategic approach in dealing with the media that plays a role in facilitating negative news between the Ombudsman's Office, its Parliament?
That's a really good question. Thank you to whoever asked that one. I regard the role of the media as, and a free press generally, as absolutely essential to the work of my office. Because it is, ultimately, it's, as I hope I covered in my presentation, it is the power of publication that really sits behind so many of the powers we use. It's the fact that we can table a report in Parliament, that it'll be picked up by the media, that it will be an evidence-based report that means that people are not, like these members of parliament in my red shirts case are not, they are accountable as a result of an ombudsman's investigation. You know, they're and people see that, and the media plays, I think, a very important part in I think, promoting the independence of the ombudsman and the role we play in the integrity framework of the country. I hope that answers the question. I could actually talk about the role of the media at length, but I'm conscious of the time, and I'm aware that there may well be other questions that people wish to ask, but it's a really important subject.
Thank you so much, Honorable Class. I would just like to give our esteemed panelists just 1 minute each to give us your last word of comment, having taken into consideration the questions that have come before you as well regarding this topic. Since Honorable Glass is on the platform, let me just give to you once. Thank you.
Well, I will, I think I've talked enough this evening for my time, your morning, but I think a small perspective I would add, because I've seen comments in the chat about powers. I don't think I need any more powers to deal with recalcitrant respondents. I think I have a pretty persuasive set already. And I do think that it is a much more difficult subject for my office to deal with difficult complainants than the difficult, the respondent. I can get the respondents, no problem, ultimately, where I want them. It's much harder to deal with the challenging complainants.
Honorable Mahana Sotle.
Thank you, Madam Facilitator. I think I take the same view that Madam Class was talking about, the issue of power. I think that's very central. But it all depends on us. I mean, how we really execute our mandate, and ensuring that people should understand that, first and foremost, we are not a court of law. Secondly, we are neither, we don't represent the government, nor are we advocates for the complainant. That we are neutral, and we are doing this just to make sure that those who are aggrieved get redress, and also, as it was said earlier, make those who are in power or those who are in authority to shine, as Madam President has said before, so that people should really appreciate that that is the specific role. We are not there to pass judgments on anybody and all that. So I think, as I said earlier also, it's just all about our power of persuasion, moral persuasion that we have, and also striving to really educate people about our role and the importance of our offices in a democratic setup. So I think that is the last point that I would want to put across. Thank you very much.
Thank you, Honorable Mahana Sotle. Dr. Wahfa, your last remarks, please.
Yes, I think the problem of, or the question of ombudsman has a double face on the part of persons and on the part of authorities. On the one hand, with regard to persons, the question is a psychological one. They fear to cooperate. And this must be really settled by the competent persons or authorities to encourage persons to cooperate in investigations. But on the other hand, with regard to authorities, they must respect the views of persons, even when their views are different from that of the official one. But also on a third level, institutions implicated in the protection of human rights and fundamental freedoms, such as NCHR or others, also must enter into contact with the competent authorities to solve problems that prevent witnesses from cooperating and from testifying and from presenting their views with regard to any breaches or violations regarding human rights and fundamental freedoms. Thank you.
Thank you so much, Honorable Wahfa. Thank you, esteemed panelists, and Honorable President Kavani for having participated in this question and answer session. I will just wrap up and give a summary of today. I think what is really important and out of this topic really is the chronology in which it has been unpacked to us. Obviously, there are ground reasons why the respondents refuse to cooperate, and Honorable Makhonasotle has beautifully outlined those. And what is important, why it's important to identify these is really, from what I've captured, Honorable Makhonasotle, is we must be able to pick up what are the systemic issues, besides just a behavioral issue or non-professionalism within the public sector, why they would refuse to cooperate with us. But there are issues of floodgates, there are issues of perceptions towards the Ombudsman Office, there are issues of not proper record management, you know, not because they don't want to cooperate, but their system is in such a manner that they are unable to cooperate with us. So it's very important that as we deal with these issues, we are also able to identify the systemic issues and be able to address them in order to make our work much easier. The environment within which public servants work might not be conducive for them to be able to effectively cooperate with us as ombudsmen. Honorable Glass then dealt with a very pertinent question on how to productively deal with recalcitrant respondents. I think the groundbreaking Richard's case really sums up how further we can take up the battle of ensuring that there is cooperation with our offices, our high powers, also ourselves trying to cooperate with government, but also going to court as a means of last resort, but also to protect our independence as officers of the Ombudsman. Lastly, Dr. Wahfa, who then dealt with the techniques to ensure that we are able to receive cooperation. These are very important tools that each and every investigator and ombudsman must be armed with, because at the end of the day, we must ensure that we are able to assist the public, protecting the confidentiality of the witnesses involved, because the witnesses must also be able to respond to some of the questions and investigations that we put forth to them, offering the legal assistance, assisting in terms of issues of research, the e-complaint system, making our system user-friendly. That's very important. Encouraging people to cooperate, protect those who tell the truth, preventing the competent authorities from abusing their powers in making the system really approachable and being able to deliver the services that they are able to deliver. And I think most importantly, and these are answers that came up from the questions that have been asked, is using public platforms, is using the media, also our outreach on educating about our mandate, because as the speakers have correctly outlined, is that there might be a confusion and misunderstanding in respect of the mandate of the ombuds. And in South Africa, we are one of the ombuds who are fortunate, even though this brings us a lot of challenges of having our remedial actions to be binding. So that is a very powerful tool for us, which has been correctly interpreted by the courts. But on the other hand, it leaves us with the challenge of a flood of litigation. But also what is critical is, how do we deal with these litigations prior? How do we foresee, and how do we enforce a tighter stakeholder relation between state authorities? And as Advocate Mkhwebane correctly said, is that we are here to assist them, to strengthen good governance, to strengthen this democracy that they are leading. Therefore, it is very important for them to understand that part of our mandate. And AOP team, this has really been a very fruitful discussion. And as I've previously said, it's difficult to speak about the respondents without speaking about the complainants. And I really hope that as the ombuds, we will take up to actually also upload the paper that Honorable Glass spoke on how to deal with these difficult complainants, because we really need this a lot, and also to download the other papers that have been spoken of here today to really assist us and actually make these a part of our tools, our guiding tools, and our investigation manuals in our respective countries. Thank you very much from my side. I would now like to hand over to Honorable Mkhwebane to please thank everybody who participated and close for us. Over to you, Honorable.
Thank you, Advocate Galega, Deputy Public Protector, South Africa. Thank you so much, Honorable Makhona Thotle. Thank you so much, Honorable Glass, and thank you so much, Dr. Wahfa, and thank you to everyone who participated. You've asked very important questions, which we've learned so much from. Thank you, facilitator, because you've summarized everything, and we've learned a lot. And the AOMA team, big up to you. Thank you so much. And we will await the webinar proceedings, because you'll post them in the website and our social media. So we will continuously refer to. And all the best, keep safe, and let's defeat this virus, and let's continue engaging. I think this makes us to work more virtually and learn more. And I can't wait for the next one, where we will be dealing with the complainants. Indeed, it's a challenge. And again, Honorable Glass, I think you wouldn't mind to come back and also share and take us through that paper, because sometimes it's one thing to read and it's another to engage and discuss issues. So thank you so much, everyone. All the best. Keep safe.
Thank you, Pipi.
Thank you so much. Thank you for everything. But let me also mention this, DPP, you are a star. Thank you so much for being there for us. And maybe I should just congratulate you for your LLM. Actually, we will change your bio accordingly. Thank you to everyone. We really appreciate you.
Thanks,
and
Professor.
Thank you so much.
I know she's not
Lovely to see you all.
Yeah,
Thank you. Bye.
Thank you.
Thank you so much.
Bye-bye.
Bye.
Thank you.
Bye.